Fans of music across the UK might have caught a story that broke in the press a couple of weeks ago about the Bonzo Dog Doodah Band, who started out in 1962 when Rodney Slater and Vivian Stanshall got together and decided to form a band, who in the 1960s made a rather anarchic style. They sent up a lot of old styles of music along the way, and eventually, as a lot of bands do, they broke up in 1970. And from time to time, they got back together again, and in 2006 had an anniversary tour. Well, in recent times, it transpires that someone actually trademarked their name, not the band, but another individual. And in doing so, a number of people got involved in a legal case. And I'm joined now by Richard Allen. Good afternoon, Richard.
Afternoon.
Well, tell us a little bit, first of all, about the background to this case, because no one could ever imagine that the Bonzo Dog Doodah Band would end up in the courts.
No, well, I mean, my involvement with the band is merely as somebody that's sort of assisting with a big box set that the major record, a large label's putting out, that's going to include all of their material, all their major label material, all their video material, etc. And I've been working with them on that for quite some time. And suddenly I had a phone call one day from one of the band, and they'd said that somebody had trademarked their name. And I couldn't actually believe that was even possible, because knowing a bit about copyright and intellectual property, you can only trademark something that you have rights in. And with regards to their name, the only people that could have rights in that name would have been the band, unless they had assigned it to somebody. So they hadn't, because that's the first question I asked them was, had you assigned your name to anybody? And then basically they decided to challenge the name by filling out a form, paying a fee, which is, there's a process by you can challenge a trademark. And they asked me to help them. So I just sort of offered my services as the person that would kind of be the point of contact at the Intellectual Property Office for challenging the name. But the band was challenging the name, and I was just acting on their behalf, signing forms and repeating what they said to me to the Intellectual Property Office. And it kind of snowballed from there, really.
Let's just try and understand this for a second or two. Someone went along, as it turns out, a gentleman called Robert Carruthers, who registered a trademark because none had been registered already, and paid, I think, £200 to register that trademark. Yeah.
There's a major flaw in the system in that you can register a trademark and they don't ask for any evidence that what you're registering is in fact yours. And I got to know another band, Modern Romance. You may remember that in the 80s, Everybody Salsa. They had the same thing happen to them. And somebody registered their name, didn't own it, they had to challenge it. It was found in their favour, but the whole process took 2 years, cost them £30,000 or something in fees, because they got a solicitor to deal with the Intellectual Property Office. And in the end, it was ruled that it was their name to start with. But again, the person had just gone along, £200, said it's my name. You can do it on your debit card. You tick 2 boxes on the internet, on an online form, pay £200, and it's yours. The only check they do is, has somebody registered it already? And just for a bit of a laugh, well, actually, is to prove how useless the system is. The Modern Romance, after they got their name back, allowed me to register their name the day after the judgment was published. So the following morning, after the judgment was published, I went online and I registered their name for £200, ticked 2 boxes, and it was mine. I then rang up the Intellectual Property Office. I said, I've just registered a name, but I don't. After there was a period of 14 days in which they said, we've done some checks, it's your name. I then rang them up and said, I've just registered a name, it's not mine. And I can't believe that it was so easy to do, not least because you just spent 2 years dealing with a dispute, and you just published a ruling that said it was owned by the individual that controls the band. So quite how it's possible for me the following day to go online and just get the name for 200 quid and a debit card is just utterly ridiculous. And that is the problem here, is it's too easy to do.
So the situation is really, and it wouldn't happen with someone, let's say the Beatles or Coldplay or the Rolling Stones, but it's entirely possible that if certain big name bands I've never registered a trademark. I could go out and do that this afternoon with my credit card.
You could, and actually, when I said to the Intellectual Property Office, do you check anything other than the register? They said no. I said, do you look on the internet? No. Now, you mentioned the Rolling Stones. I'm sure if you tried that, well, firstly, it's been registered, but let's say for the sake of argument, it hadn't been. You would think somebody at the Intellectual Property Office would go, oh, I know that band. I think this is probably suspicious. The thing about the Bonzos is that they're very well known, but not very well known to everybody. So it didn't get, nobody asked any awkward questions. But from what I can tell, they can't ask awkward questions anyway, because the only thing they're allowed to look at is the register. So yes, in theory, you could register Paul McCartney as a trademark if he hadn't done it, and he then has to take you to the tribunal, pay a fee, employ somebody to deal with it, and the whole thing takes about 2 years.
So quite a chunk of your life has been taken up with a case that you were never really involved with, other than the fact you'd been working with the band, and then ended up, because of this gentleman, Mr. Carruthers, challenging what was being said to him by the band, basically.
Yeah, I mean, it got even more ridiculous than that, because, of course, I'm not going to put things on a form that I'm dealing with the Intellectual Property Office unless it comes from the band. I've got no interest in putting false information on forms. So, of course, everything on that form and all of the paperwork that we submitted came from the band. But the problem is that they want a representative. So they want somebody to act as a representative, which is what I did. So my name's at the bottom of everything as the person acting on behalf of the band. For some reason unknown to me, the other party decided to issue high court writs against the band, which don't make any sense anyway, because the IPO is dealing with it, but they decided to add me to it. Now I'm just the witness, so I'm just the person filling in the forms. So I got dragged into it, and I had no choice. And the other bizarre thing about this is that not only can you register a band name with no evidence whatsoever, you can also apparently take out court proceedings against somebody based on complete nonsense, and it will get taken seriously all the way to the point where it gets to a judge, who then looks at it and says, what a load of rubbish, and throws it out, by which point you've spent vast sums of money employing people to put common sense in the right format and present it to the court. So yeah, even more ridiculous.
The Bonzos, throughout their career, they made a living out of sending up situations like this, and yet they find themselves in the middle of one.
Yeah, it was Kafkaesque. I mean, I remember I was on the phone to the IPO and I said, this is Kafkaesque. And they said, we try not to be Kafkaesque. I wish I'd recorded that. They are, the court system is, at the end of the day, nonsense is only nonsense if it's called nonsense by a barrister and the judge decides it's nonsense. That's basically, which is, in some ways, what a waste of time, what a waste of resources, what a waste of everybody's effort. I mean, at one point, the point was made in court by the other side. They couldn't understand why I was involved. Neither could I. I mean, I was added to the writ, so therefore it's hardly surprising I turn up in court, is it?
So where do things stand now then, Richard?
Well, the whole thing got thrown out as complete nonsense, which it was. I mean, I was involved in a fraud case. You can't bring fraud proceedings against somebody unless you've got absolutely clear evidence that there has been a fraud, which in this case there wasn't. I mean, what the suggestion was that the members of the band didn't own the name. I mean, it's never going to fly. They were the band. But the other thing is that it got thrown out, and we're going to take it further. We're going to try and put an end to this registering names, on a debit card nonsense, because it's prehistoric. I mean, this obviously the system was designed when people wrote it with a quill pen on a piece of parchment. It's not designed for the modern day. If you register a band name, the minimum you should be required to do is to provide, at the point you register the name, evidence that you are the band, some kind of backup to that, which should then be logged on the system. So then if at a later point someone challenges it, you can't start making stories up or backtracking on what you said when you registered the name. The problem we found was that because there's no evidence filed at the point you register the name, the person that registered the name can just keep changing their story as to why they registered the name. But of course, if you'd been forced to put something down to start with, you wouldn't have been able to do that. Just, you know, common sense. It's staggering to me that something so important is so poorly designed.
How frustrating has this been, Richard? Because it sounds to me like it was a huge distraction from what you should have all been doing.
Yeah, well, it took up a huge amount of time. I mean, weirdly enough, there were points I was thinking, oh, I'm quite glad I'm involved in this, because it's so bizarre that it was almost entertaining. But other times, you know, it's very worrying because, you know, it's very costly business. We had to crowdfund money because the band's not wealthy. You know, I'm certainly not going to put money into a court case involving a name that's not even anything to do with me, as much as I'm a fan. So it did take up a lot of time. Fortunately, I've been involved in lots of litigation, so adding me to the writ was a bad idea, really.
Now, people talk in legal terms sometimes of landmark cases. Will this potentially go down as a landmark case for bands of the future?
I think it will, because it looks like, from what I can see, there's never been a case where somebody that isn't in a band trademarks their name. Normally, you have competing versions of the same band. The famous one was Wishbone Ash. Hawkwind was another one, where you've got two separate factions within a band. One of them trademarks a name, the other then doesn't like it. I mean, that, you know, the first question I asked the band actually was, has there ever been two Bonzo Dog Doodah bands? Luckily there hasn't, because if there was, I would have run a mile from it. But to have somebody that's not in the band register the band's name, you would think that that would have been dealt with. But I think the reason it probably wasn't is it's such a ridiculous thing anyway that no one's ever tried it before. So the court has ruled that you can't do that. They had to.
This case has been running for a while now, and sadly, two of the people involved, Martin Ash, who was better known as Sam Spoons, and Neil Innes, who was one of the leading members of the band in terms of songwriting, both have passed away and aren't around to see the victory, unfortunately. But some, you know, the rest of the band are still around and planning a gig at the end of this year.
Well, it's quite sad because I spoke to Sam not long before he died, and he was adamant that we continue with this. I saw Neil just before Christmas, and you know, he was really gung ho for it, because you can imagine if you created a band in your youth and you've grown up with it, and to have somebody then register that as a trademark and own it must be, you know, it's like having your soul stolen, isn't it? In some respects. But you know, the trademark law on band ownership is very clear. There's been huge, weirdly enough, the case that defined most of it was Saxon. Saxon had a massive fight over their name, which is quite a funny case to read. But you know, it's been decided that the band are the last people remaining who are still continuing as the band. That's the precedent. So that's clear. What hadn't been decided was, can somebody who isn't in the band trademark the name just because they've worked with them? And the answer to that, unsurprisingly, is no. Because if the answer had been yes, you can just imagine the precedent that would have set.
Well, thanks very much for talking about this today, Richard. One last question for you. Where do you see this going now? Are there any MPs supporting the cause to try and batten this down for future?
We've had positive noises from the Intellectual Property Office. I think they realised the problem this is causing them. And there seems to be a willingness to A, look at this, and B, see whether there's a solution to possibly changing the law. Well, the first thing I look at is the law being applied incorrectly? I suspect it's being applied correctly. And then the second thing is, does it need changing? And I think the answer is yes, it just needs a very simple amendment, and that is you have to provide evidence you are who you say you are at the outset.